Emotional court hearing in Texas today as both the genetic and surrogate birth mother of a newborn testified in what's going to be a landmark legal battle over a surrogacy agreement and maybe surrogacy at large. A California couple hired Alaska resident and nurse McKenna West to carry their baby, but then asked her to terminate the pregnancy at 20 weeks when testing showed the baby had a life-threatening heart defect. Now, the surrogate traveled to Texas, which is a state with very strict abortion laws, and gave birth to the baby boy. The baby boy, by the way, is in critical condition after undergoing the first of multiple surgeries. Well, biological parents and the surrogate are now suing for the right to make the child's medical decisions. The genetic parents are also seeking more than $100,000. They allege the surrogate breached their agreement. Healthcare lawyer, author, and policy expert Harry Nelson joins us now from Los Angeles on a case that is getting the headlines, but might be a little complicated from a legal standpoint. So walk us through this. How common, or I guess uncommon, is it for a surrogacy agreement to address the subject of termination?
It's not uncommon at all. I wouldn't say that it's part of every contract, but certainly, like all contracts, it has a language about when the contract can terminate. It's unusual for these contracts to specifically address termination of pregnancy, but the contract, naturally envisions where things could go wrong on all kinds of levels. So it's fascinating that this is really one of the first cases we've had where this clause has come to be such a focus of attention.
Really, in a master class for contract law studies here in the United States, it's complicated by the fact that there are 3 different states involved. So which laws apply when the parties cross state lines and leave the state where the contract was entered into?
Yeah, it's a great question. I mean, the parents here, I should say the surrogate seeking parents were in California. The contract was written to conform to California law. McKenna West, the gestational surrogate, I'm hesitating to say mother, but who delivered the baby, was in Alaska at the time. She then traveled to Texas. So we have California versus Alaska versus Texas on a whole series of questions: the right to the effectiveness of the surrogacy agreement, the right to terminate, who has power over choices of medical care for a child with a disability. Really like an array of questions and 3 different states that the judges, I don't envy the judge for having to sort through this.
And arguably states that have entirely different political leanings traditionally. Another question I have is, could this change surrogacy law going forward?
This case is going to be an important one, and people are going to be looking at this for a long time to come. One of the most interesting issues is that Texas and California have very different laws. In Texas, a gestational surrogate arrangement like this required advance court approval, which is why just a week ago we had the Texas Attorney General ready to step in and and invalidate the California order. So now the question is that the state of Texas has backed off now that the child has had surgery. The question is there going to be respect under the constitutional full faith and credit provision that Texas will give to say that the California contract for surrogacy was valid? Or is McKenna West going to be successful in challenging that and having a Texas court invalidate it? So that's going to be an important question that I think, is going to really shape how these contracts are prepared in the future and how people think about the risks under them.
Harry Nelson, thank you so much. Good to see you.